legal research methodology and tools of study with case study continues. Law lives by its sanction. Then there must be a sanction for every law. If there be none in the books, the common law will not for that reason stand by. No, the common law, its own motion will create the sanction. This is the well settled principle before this case. The judges summoned to advise the lords gave differing advice. Chief Baron Ward and Barons Barry and Smith agreed with Sir John Holt. Chief Justice Trevor and Baron Smith supported the view of the majority of the court below. The Lord Keeper of the Great Seal has no voice in the matter. Not being a peer, he can only put the question. Lord Somers, the ex-chancellor, argues for the view of Sir John Holt, and he prevails. 200 years ago, an assembly of 660 noble lords were met together to hear arguments and give judgment in the House of Lords. The immediate subject of their meeting was an appeal in an action between Matthew, petitioner, and defendant, but on the result of their deliberations depended not merely the satisfaction of one of two litigating parties, but the whole future progress of English law. Queen Anne was upon the throne, and the Lord Keeper of the Great Seal was Sir Northern Wright. It continues. After this gathering, Lord Somers, the ex-chancellor, argues for the view of Sir John Holt, and he prevails. After hearing counsel at the bar to argue the errors assigned and etc. After due consideration of what was offered thereupon, it is this day ordered and adjudged that the said judgment given in the court of Queen's Bench, such as following, shall be and is hereby reversed, and it is further ordered and that the plaintiff recover his damages by the jury assessed in the Queen's Bench, and also to recover the further sum of £10 for his costs in this because sustained by this court to him adjudged. Lord's Journals, reference Lord's Journals, 14th January 1703. Whitaker, Wield, and Mantag, you must confess yourselves beaten. White, Talboys, Bell, and Hayden, you must pay the damages which the jury have assessed against you, and £10, a considerable matter in those days, for costs beside. Once again, repeat the legends who sacrifices for this field of juries. Whitaker, Weld, and Montague, you must confess yourselves beaten. White, Talfoys, Bell, and Hayden, you must pay the damages which the jury have assessed against you, and £10, a considerable matter in those days, for costs beside. The House of Commons may be thrown into a transport of fury. The House of Commons may be thrown. The House of Commons may be thrown into a transport of fury. Reference Campbell's Lives of the Chief Justices, Volume 2, Chapter 24, page 160. Once again, and I tell the bibliography. Campbell's Lives of the Chief Justices, Volume 2, Chapter 24, page 160. The House of Commons may be thrown into a transport of fury, but it will be all of no avail. Their resolution is that the qualification of an elector is not cognizable elsewhere than before the Commons of England in Parliament assembled, that petitioner having commenced an action against the bailiffs of Aylesbury for rejecting his right is guilty of breach of privileges of this house, and that whosoever shall in future commence such an action, and all attorneys, all counsellors soliciting or pleading the same are guilty of the breach of the privileges of this house, for which they may expect continued punishment. Parliament was shortly afterwards prorogued During the recess, other electors of Aylesbury, whose votes had been rejected like that of petitioner, brought fresh actions against the returning officer. As soon as Parliament met, these plaintiffs were all committed to Newgate for breach of privileges of the House of Commons. The captives sued out writs of capias corpus to the Queen's bench, and the quarrel between the Lords and Commons lasted until the dissolution. The story of that quarrel and of the events to which it have rise is too long to be told to share here. Suffice it to say that the judgment of the House of Lords upon the question, which was the subject of the battle of plaintiff and the defendant, has never been and never will be reversed. Ibijus ibi remedium. Ibijus ibi remedium may be accepted thenceforward as one of the first principles of the English law. Now you can guess the leading case law in my legal research methodological presentation, mainly taking as a tools of study as a prima impressionis. The term first utilized by Justice Powys, Powys, Powys. He only first used this legal maxim, but in first reported case law, prima impressionis, just think of it. Now I came to the reveal the truth. As it is in the Campbell's Lives of the Chief Justices, Volume 2, Chapter 24, page 160. That is, that the qualification of an elector is not cognizable elsewhere than before the Commons of England in Parliament assembled. That as by having commenced an action against the bailiffs of Aylesbury for rejecting his vote, is guilty of a breach of the privileges of this House, and that whosoever shall in future commence such an action, and all the attorneys or counsellors soliciting or pleading the same are guilty of a breach of the privileges of this House, for which they may expect continued punishment. Yes, finally, the plaintiff asked by win the battle of justice. Ibi just ibi remedium. That famous leading case law is as by versus White, ASHBY versus WHITU, White. For we are achieving evolutionary process of judicial precedent or elsewhere judicial activism through all over through the international courts or international court of justice. The term um, uh, recorded by Lord Powys, such as prima impressionis, and which is guided also by the Justice called judicial activism or judicial precedent to preserve the Grenham theory of their own land law of any nations, is thankful to this wonderful argument of all the legal legends, predecessors, aspirants, seniors, including this Lord Powys, who said prima impressionis in the petitioner side. That petitioner plaintiff is asked by, that respondent is White. This leading case is asked by versus White. Go ahead, rule your own arena. Thank you.